The assumption in most parts of the world for most of human history was that law is not singular but multiple, right? So this idea of legal monism, the thing that we take for granted in secular modernity, is so recent and narrow in its footprint, both geographically and historically, that it's the fact that we can take that as the starting presumption is very much not helpful definitely from a historical perspective, but it also what is particularly short-sighted about is that if you look, for example, at the history of Buddhist law.
Hello and welcome to Protean View. I'm Hamid Said Bushra, and I'm joined for this episode by Benjamin Schonthal, Professor of Buddhist Studies and Asian Religions at the University of Otago and co-director of the Otago Center for Law and Society. Our discussion today takes as its point of departure Ben's recently published book, Courts, Constitutions and Karma. However, our conversation takes us to broader topics, including religion and religious law, secularism, constitutional law, and legal pluralism. Before the discussion begins, a quick thank you to our supporters without whom this episode would not be possible. If you like what we do here at Protean View, please consider joining our community on Substack at muftah.org and Patreon at patreon.com/ProteanView, which you can do for as low as $5 a month. To help keep this show running, please do follow and rate us on Spotify, Apple Podcasts, YouTube, and wherever else you find your podcasts. And don't forget to sign up for our newsletter at muftah.org to stay updated on the latest from us. Thanks for listening and for your support. And now here's my conversation with Ben Schonthal. Ben, welcome to the show. And for starters, congratulations on publishing your latest book, Courts, Constitutions and Karma. What can you tell us about the genealogy of the book, the story behind how it came about, and how it was like writing it?
Thanks so much for having me. Great to have a conversation with you. Yeah, so the book, I teach in a religious studies program. I'm a scholar of Buddhism who also works on socio-legal studies or issues of law and religion. And my first book, when I was writing my first book, that was really on constitutional law and religion in Sri Lanka, although thinking comparatively as well. The focus of that book was primarily on the constitutional regulation of religion. So thinking about what happens when conflicts involving religion go through the public law system in Sri Lanka, and what's the history of developing religious rights protections and special preferences for Buddhism in Sri Lanka's constitution. And when I was writing that book, or toward the end of when I was writing that book, I was starting to do interviews and speak more with Buddhist monastics in Sri Lanka and asking them in some cases about their own interpretations of law and their own legal systems. And it was then that I started to learn, and I'm in a way now surprised that it surprised me, but I was surprised by the sophisticated and robust and kind of really complex contemporary legal systems that were happening within monastic fraternities. So I had been familiar from studying Buddhist studies with the ancient monastic codes of conduct for monks, particularly the Vinaya Pitaka, which is we would call it the canonical code of monastic law that's thought to contain the instructions given by the Buddha himself for monastics. And any person who studies Buddhist studies will be familiar with that particular text, ancient text. But I had not learned a lot about the contemporary monastic legal systems in Sri Lanka and the way in which that text was not just put into action in contemporary monastic life, but was augmented and added to, and in some cases reinterpreted through contemporary legal architecture within the monastic fraternities themselves. So monastic fraternities had new constitutions that operationalized some of these Vinaya principles. They had court systems. They had, this elaborate system of judicial training and so on, or at least the monastic groups that I was speaking to. And I sort of became fascinated with just the internal legal system of Buddhist monastics in Sri Lanka, which sounds like a kind of a marginal interest maybe, but is actually really significant in Sri Lanka and in other parts of Asia. I mean, these are large non-state groups that they own large amounts of property. They contain lots of members. They're very influential politically and culturally and religiously, obviously. So I just became fascinated by these systems, and I wanted to write more about them. And so I was interested in the history of the interaction between the monastic legal system and the state legal system in colonial and then independent Sri Lanka. And so looking at the way in which colonial courts were dealing with these questions of monastic law, and contemporary courts have dealt with them. And so it was this big kind of, I guess, archival hodgepodge of interesting materials, I thought.
Fantastic. When you talk about Buddhist monastic laws, are these applicable only internally within the monastic communities, or are they somehow more broadly applicable to Buddhist communities beyond the monastery?
So Buddhist monastic laws are, in the first instance, in the Theravada tradition. So there's a number of major traditions of Buddhism. In that tradition, monastic laws, what I'm referring to as monastic laws, are generally just the laws governing particular monastic groups or monastic complexes. So that being said, however, these monastic legal texts and these monastic legal categories and ideas have really influenced state law as well. So if you look, for example, at contemporary state law in Sri Lanka, a lot of the categories and terms, so the term for court, the term for accuser and accused, the term for adjudication, and so on, these are terms which can be traced to monastic legal terms. And so there is a long history in Sri Lanka of interaction between monastic law and state law. And I mean, my feeling, looking at the materials I've looked at, is that there does seem to be a lot of interaction between, at least in the 19th century and before, notions of justice, notions of due process, notions of what a proper dispute resolution setting would look like, that circulate between monastic and state law as well. But in the contemporary case, so if you look at, who does monastic law serve in contemporary Sri Lanka, it really is mainly Buddhist monastics first, and second, the lay communities that interact with the Buddhist monastics. So monastic law in some cases will cover disputes between lay persons and monastics with a particular fraternity. And then, generally speaking, the system of law also governs properties, monastic properties, and these are there's vast amounts of monastic property in Sri Lanka. One colonial estimate at the sort of, I think it's from the 1830s, was that monastic estates in the largest central portion of Sri Lanka controlled something like 20 or 22% of all arable and paddy lands. So we're talking about massive amounts of land as well, and monastic laws would, in the first instance, be the property law governing those lands.
Great. So that was actually going to be my next question, the question of relation between these monastic constitutions and state legal systems. So you obviously touched upon this perhaps from the angle of its relation to Buddhist communities more broadly, but perhaps you could elaborate a bit more, and maybe specifically on this question of the incorporation of elements relating to the Buddhist religion in state constitutions, whether in Sri Lanka, but also, as I understand it, in other Buddhist majority states in Asia.
Yes. So there is this other way in which the monastic legal system is significant, in that it's in Buddhism, the monastic community is uniquely important, and particularly in Theravada Buddhism. This is not true in all traditions of Buddhism, but most traditions of Buddhism have a special place for the monastic community. And the monastic community is considered one of the so-called three gems of the religion. So the Buddha, his teachings, and the monastic community. And all three are considered necessary for the continuity and preservation of Buddhism. And therefore, the laws of the monastic community, which are supposed to ensure their discipline and internal cohesion of the monastic community, are also important as essential for the survival of the religion itself. So in a way, anything that's of concern to monastic law is also of concern to people who are interested in the propagation and preservation of Buddhism. Now, this is significant because of the Buddhist majority countries in Asia, 6 out of 7 of them give Buddhism a special status in their constitutions, right? So this is Myanmar, Sri Lanka, Thailand, Cambodia, Laos, and Bhutan, and Mongolia. So Mongolia is the one that doesn't. But if you were to include the Tibetan government in exile, they have their own constitution. That also gives a very special place to Buddhism. So to the extent that state law and the constitutions of Buddhist majority countries give special prerogatives to Buddhism, there is a special, I guess, place, if you like, for monastic law within that configuration. So an interesting thing that some of the listeners may find interesting in Sri Lanka is that there's been Sri Lanka has a constitution with a special clause that gives Buddhism, in the language, is the foremost place and obligates the state to, quote, protect and foster the Buddhist sasana, which is the dispensation of the Buddha. So that's a very big term. It's a term that includes like the teachings of the Buddha, the properties of Buddhist monasteries, manuscripts and so on. It's the entire kind of material and non-material legacy of the Buddha. So the state, according to the Constitution, Chapter 2, is obligated to protect those things. Now, part of that obligation is the obligation, or it has been interpreted this way, to protect monastic law or the Vinaya, or the discipline and internal harmony of the monastic community. And there's been a number of really high-profile court cases in modern Sri Lankan history in which the higher judiciary has been called upon to action that obligation through exercising a certain kind of interpretation about what monastic law can permit and non-permit for monks. So one example is a case that I've written about where a monk wanted to get a driving license and went to the DMV, and the officer at the DMV gave several reasons, including, look, as a representative of the state, it would be transgressing my obligations to this Chapter 2 of the Constitution to issue you with an ID because, the Vinaya doesn't permit monks to drive. Now there's a lot of interesting, you can imagine, the legal questions about that within the monastic legal thinking, particularly because there's no rules about motor cars in the Vinaya. There are rules about vehicles, but that's like sedan chairs and litters and other things. And indeed, that rule is a little bit larger than I think anyone would want to sort of use in the contemporary case either, because it basically forbids all monks who aren't sick from riding in any kind of vehicle. So that would mean like monks couldn't go in planes or buses, and no one wants that. So the long story short of that case is basically you had the court being drawn into this question of should monks, according to the terms of monastic law, which must be supported through the constitutional obligation to Buddhism, should these monks be permitted to have driving license or not? And on each side of the case, you had people arguing, monks, including monks, arguing that the Vinaya did permit it or that it didn't permit it. And so throughout, Sri Lankan history, and there's other examples. There's examples of monks who want to become a lawyer. There was a recent case about whether or not the government should recognize female monastic ordination, so bhikkhunis or fully ordained Buddhist nuns, for complicated reasons, which we can talk about it if you want. Most Theravada majority countries do not recognize or officially recognize fully ordained female monastics. And Sri Lanka the government has historically not done that, although there's been a very vibrant community of bhikkhunis, of Buddhist nuns who live in Sri Lanka. They just don't get the privileges and recognition from the state as being bona fide. And so there was a recent court case in which a nun who was refused an ID card that said nun on it appealed, made a petition, a fundamental rights petition to the Supreme Court under equality under the law, saying that her equality under the law was being violated. And as part of the arguments in the case, and as part of the ratio of the judges in giving the case, the issue of Buddhist monastic law came up there, right? So it's something that comes up pretty regularly in Sri Lanka and in other Buddhist countries as well, because of this constitutional obligation to support Buddhism and therefore to also be supportive of, the proper practice of monastic law.
So when you were talking about the kind of interpretations that happen on both sides among the monastics and among state officials regarding monastic law, it just reminded me obviously of similar things that happen in Muslim majority countries vis-a-vis the Sharia, with perhaps the only difference being the fact that due to the kind of anti-clerical nature of the vast majority of interpretations of Islam, the law really kind of applies to everybody. So it's kind of, it affects people much more widely, but the same kind of wrangling happens over interpretations of Sharia, among jurists on the one hand, but then also among, legal officials and state officials. So there's a certain kind of parallel here, but obviously with differences, perhaps particularly in terms of its applicability to kind of larger swaths of the community.
And if I might ask you, I mean, one interesting dynamic here that if you look comparatively across the Buddhist majority jurisdictions that you see is that most other countries have, in part to deal with these kinds of dilemmas, created a official monastic hierarchy that can act as, among other things, jurist of last resort in debates about orthodoxy. But in Sri Lanka, there have been many attempts almost every decade since independence, which I write about actually in the third part of the book, to create such a hierarchy in Sri Lanka, and it's never happened. And so therefore you have the issue of devolved legal authority or devolved jurisprudential authority among monastics. So for example, if you have, in the case of the driving monk, it was difficult for the court to, although ultimately the court sided with the sort of more prestigious elite monks, there was still a kind of a bona fide, plurality of opinion about Vinaya among monks. And indeed, if you have debates between the monastic fraternities, each with their own different hierarchies, it can become a real problem. But in a place like Thailand, where you have an official monastic hierarchy, you have a monastic hierarchy that's backed by the state, has effectively police powers and so on. You don't have, there's not a kind of as much concern about the, multiple jurisprudential voices that are dealing with these debates. What's the case? What's your impression of the way these things play out with Sharia in various jurisdictions?
So this is one of these main points of contention, and I would say probably one of the biggest unresolved issues in kind of contemporary Islamic political theory. Because on the one hand, if you look at it classically, in the kind of classical, especially pre-modern tradition, the community of jurists who would study these issues and issue legal opinions had much independence from the state. So they wouldn't have to kind of feel pressured. It was like Wa'il Hallaq obviously talks quite a lot about this in his works, where he shows how the community of jurists, particularly those issuing legal opinions, their kind of, job of ifta, giving fatwa, was one which was kind of radically independent, and also one which was very community-based and community-grounded. It wasn't necessarily kind of restricted to a particular kind of elite. You could easily quite, join the ranks of the jurists if you, so studied. And the state wouldn't really be able to pressure people in terms of issuing those legal opinions. The law, once it is, set and agreed upon, it would have to be kind of applied by the state, whether they liked it or not. In reality, sometimes there would be cases where, you would have state-appointed jurists who would issue fatwas kind of more in line with maybe what the state desired. And there was a gradual process of officializing this through this notion of the Grand Mufti or the State Mufti or whatever, right? And this is a fairly late development which has been inherited, where you have like official religious establishments of Saudi Arabia, of Turkey, of Jordan, whatever state has the kind of Grand Mufti or their official State Mufti. This is the current situation, but even here it hasn't been able to, there's been tensions. It hasn't been able to hold, because what do you do when you have jurists who are not connected to the official state apparatus, who are nonetheless influential, and they have opinions that differ, right? There's been obviously a great effort to stamp those voices out, either, in certain more authoritarian states, imprison them, or, shut down their ability to speak, and in other instances to try and just drown them out by, for lack of a better term, propaganda. So there is this tension between kind of the official line that states want to push or want to adopt in terms of legal opinions, but then this community-based reality that has been the case, since pre-modernity. I think this is where I'd say that the biggest unresolved issue when it comes to contemporary political theory comes in, is that even if we were to allow and concede the classical position that legal opinions are down to the jurists and it's not something that the state can influence, there does come a problem when it comes to application, because a state needs to apply laws. And if there's going to be 2 or 3 or 4 different opinions, there must be a mechanism for legal adoption. And I think that hasn't been kind of theorized yet, or adequately anyway, because when you have more than one opinion, and it relates to something that the state must do, then the state will have to kind of adopt, and there has to be some kind of mechanism for doing so. And maybe in a way which is not necessarily enforcing or coercing people who might have another opinion. I think in many matters, this would be resolved simply through legal pluralism, right? So there's more than one court that operates according to these different opinions or different legal schools, and that operates there. But then when it comes to, let's say, things that the state has to do, there's let's say, something to do with, let's say, taxation, right? The state has to collect taxes. Is it going to go by this opinion or that opinion or the other? And then I think there has to be some kind of mechanism for adopting a law. And I think that that's something that is, as I said, under-theorized at the moment. So this actually maybe is a good segue to talk about legal pluralism, and perhaps also just more broadly to talk about religious law and secular law, or state law and, the laws of religious communities. I think the general discourse or the kind of received knowledge that people have is somehow that law in the world, in today's world, is secular, and then there are these outliers or these people who kind of refuse to do this, who typically especially the media discourse will fall on Muslim majority countries. Oh, they can't let go, they can't differentiate between politics and religion and whatever else. From what you're saying, there seems to be a lot of this in other communities as well. So, but Buddhist majority countries, there seems to be a lot of crossover between, secular law and religious law, or between state law and monastic law. So perhaps, we can talk about that, and we can talk about how that relates to the question of legal pluralism.
Absolutely. And in some ways, maybe I should have started here, which is that there's a whole bunch of biases built into, the various disciplines that we would come to these questions through, right? So in comparative law, to the extent that they even consider religious law at all, it's definitely the monotheistic religious laws, and definitely the codified sort of versions of those. Buddhism, I mean, even it's surprising that, even in anthologies, which there's anthologies of religious law that have come out recently that, Buddhist law is just not even mentioned, right? As though it was a legal tradition. And, and in some ways, Buddhist studies is guilty of this kind of thing, in the sense that there's a presumption in favor of older textual philosophical accounts of Buddhism. So anything that's modern, anything that's, lived, let alone legal or political, has been, marginal in the tradition, in the discipline. So that's changing a little bit now. And all of this is part of, I think, a broader set of assumptions about certain sort of secular pretensions that we have about our own legal system, which we can get into in a minute, but also about, to the extent that we want to acknowledge the influence of religion on law, we've done it very selectively and episodically. And of course, Islam is the one tradition that that I think people are unsurprised if you say, Islamic law is this important legal tradition. Although it's, I guess it's maybe also worthwhile noting that, there's something like 30 countries in the world in which Christianity is also a preferred religion. So we have this unrealistic expectation of constitutions even, which is that most of the world's constitutions are secular. And indeed, I think 55% don't give a special status to religion, but 45% do. So it's very much the case that religion is wrapped up even in the guiding laws of countries in most parts of the world, right? Now that's just at the facial level of acknowledging religion in state law. But if we look then even more at the influence or the legal milieu of the world, I mean, religious law is absolutely central in most parts of the world, including, of course, the Buddhist world. So I came to writing. There's this book that I've just finished was the beginning of a next project, which I'm working on right now, which is looking at Buddhist legal traditions across Asia. So thinking about the Buddhist legal tradition. And if you think about it, like this is one of the world's oldest living legal traditions, right? It's not some marginal thing. These monastic groups, these Buddhist groups, they are some of the largest in terms of membership and in terms of like property and so on, non-state actors in the world. Like, why would they not have robust internal legal systems? The reason that we don't look at for them is because of these biases I just talked about. This, the bias for the otherworldly nature of Buddhism, bias for, the ancient and textual versions of Buddhism. Monastic constitutions are everywhere. They're some of the largest, the Chogyey order in Korea, the largest Buddhist monastic order there, massive, super complex internal legal system with bylaws and, amendment procedures and so on. So there's certain lines of sight that have been, we've been reluctant to take. And to the extent that we've taken them really only for certain traditions, And, if you think about it, so I've just told you there's this Buddhist legal traditions are some of the oldest continuously practiced in the world. About half the world's population live in areas where these legal traditions were thriving or are still thriving. And so if we think about this, if this is the framework that we're coming to engaging in our study with, then legal pluralism is not some aberration or some thing that's nice to think about. It's the core, right? I mean, all these places are deeply multi-legal. And the circulation, as I said before, it's not just a circulation of, or this is one of the things I'm arguing in the book. It's not just a circulation of otherwise sealed legal systems that sort of influence each other in the odd occasion, and even to the extent that we can speak about an ecclesiastical legal system, which you would think is the most insular, the most isolated kind of system. Even these systems are influencing the development and understanding of the legal systems around them. So part of what I was trying to do with the book, I suppose, is something that it wasn't an agenda I went into the book with, but it was something that I came out with in terms of really wanting to write about, which was that there's a real dissatisfaction with, I think, the ways we tend to look at or think about legal pluralism, just not everywhere in scholarship, but even in some of the areas of scholarship that do take legal pluralism seriously, just to make clear what I mean, this is, the presence, we often define it as the presence of multiple normative systems or multiple legal systems within the same space. To the extent that we talk about it, we often think about it as like a kind of a structural condition, right? So you have ecclesiastical law here, you have state law here, you have these things. And yes, there's some overlap in the Venn diagram, but these are, more or less stable domains. And what we need to do as scholars is to map their contours, talk about the transactions between them. And if we're normatively oriented, or if we're like policy people, we should develop certain policies to reconcile them. That's often the language used, right? So we want to create certain bridging norms, or we want to devolve certain powers or so on. We want to clarify the precise boundaries of their respective jurisdictions. That's kind of, I think, the ethic with which a lot of policy writing and scholarship on legal pluralism has taken place. But actually, what I was finding in Sri Lanka was that when you look at what this thing looks like on the ground, what the multi-legality looks like on the ground, it seems to be a slightly messier composite, right? So you have this universe of, I guess, legal things, right? Codes, norms, courts, professionals, etc., that purport to be the stuff of law. So you have these very, very real things in the world. And yet you have this varied set of practices through which people are bringing order and making sense to the multiplicity of those things. So you can have the same composition of legal stuff, and you can have these different interpretations and ways of bringing these things into proximity that, in effect, bring about different engagements with and enactments of legal pluralism. So you can have, at the same time, in the same milieu, you can have one monastic group saying, monastic law and state law are well aligned. Monastic law and state law are analogous, they're complementary, and so on. And then you can have another monastic group saying quite a different thing, that monastic law and state law are at odds. State law is totally incommensurable with monastic law and needs to be protected from any encroachments on it, and so on. And so rather than a single state of legal pluralism, rather than this thing that we can map out, what we have is, I guess, a plurality of legal pluralisms, I call it, or this, multiple accounts of multi-legality that are concurrent at any one time. So my, I guess, theoretical intervention in the book is to say, what does it mean for us to look at legal pluralism this way? What can we gain from approaching, this complex state of multi-legality through this on-the-ground perspective of these multiple competing views, multiple competing enactments? I'm very uncomfortable with the idea that these are just interpretations of an otherwise singular phenomenon. I really do believe that we bring about we enact the kind of multi-legalities of which we speak, that it's not just that we have different interpretations of the same universe of stuff. We're actually bringing about different possibilities, different sense of obligation, different kinds of expectations, different possibilities for dispute resolution, and so on, by calling forth different visions of multi-legality.
And yeah, obviously, as you mentioned, multi-legality itself takes many different forms, whether it be the multiplicity between state law and, in this case, monastic law, or the existence side by side of multiple different legal systems, perhaps religious, perhaps jurisdictional, or otherwise. From your experience in Western in general, but perhaps specifically Anglo-American political theory and legal theory, there seems to be a great discomfort with the possibility or notion of legal pluralism. Number one, I guess, how might we explain this, or why is there this discomfort? And if there is some kind of maybe opening, it often might be more comfortable with some forms of it than others. So, for example, jurisdictional legal plurality, this is something that we often find on the ground, state law, federal law, etc., versus other forms, such as, for example, different communities having different legal systems or laws, seems to be somehow something that causes a lot more of a discomfort. So yeah, how might we kind of explain this and navigate this, and what might be the problem with viewing things in this way?
Yeah, no, you're absolutely right. Legal pluralism is itself a kind of, or the subfield of legal pluralism it was itself, I guess, difficult in the birthing, if you like. And there's a number of different, I think, explanations. The most obvious one is that there's this, I guess, original sin of legal pluralism, which is that in order to have legal pluralism, you have to define law. And there's, like religion, like every category we work with, there's all kinds of issues with trying to define law. And historically, or I guess in the early phases of scholarship on legal pluralism, a lot of the heavy lifting, I think, was done with taxonomies of legal pluralism. So a distinction between strong and weak legal pluralism, between official legal pluralism, state-mandated, guided legal pluralism, and unofficial legal pluralism, between the different types of non-state law, and so on. I think even among some of the early proponents of legal pluralism, there was some discomfort with the concession that basically anyone could have law. So there's always this tendency to want to put boundaries around the phenomenon we're talking about, to distinguish, whatever the group norms of your bowling league from what goes on in in a monastic community, for example, or what goes on in a civil court. So that's definitely, I think, part of the discomfort. There's another, I guess from my perspective, one of the ongoing conundrums when you're thinking about legal pluralism is that you're, in a way, always playing two kinds of games. One game is to think about legal pluralism through the perspective of state recognition. So monastic law is two things, right? It's what these monastic communities understand to be monastic law, what they call bhikshu nitya in Sinhala, what some of my informant, like people I was speaking with would refer to as bhikshu nitya. But it's also what state court judges, what lawmakers are, how they're limiting it. So when you're speaking of it, you're speaking of, on the one hand, something on the ground which is a little bit more fluid and is the object of human designations. And on the other hand, you're kind of also maybe speaking about certain things that are recognizable to authorities as well. So there's always, and I think this is true of, for me, I guess I'm a little more comfortable with this from religious studies, right? Because this is what we're always doing with religion. We're playing this game where everyone knows I'm using the category of religion in this imperfect, like I'm saying religion, but I don't really mean religion, capital R religion. I mean this, imperfect collection of human phenomenon that I'm, provisionally designating as religion for the purposes of discussion. And so I guess, playing that double game was a little more comfortable with me in thinking about law, but it is definitely not something that, I guess, policy-oriented, black letter law type people, it's not necessarily a game they want to play. So in my experience, in the legal academy, it's much more, the tendency is much more to say, okay, well, given the messiness of this other world of non-state law, let's just hold on to, well, at least we can all agree that this is law, and let's just stick with that.
Yeah, I think it's often a similar frustration for people who work on Islamic law. It's kind of a similar experience, particularly in, when navigating questions such as minority communities or minority situations. And I think it often, I think this is another dimension to it when studying it there, is that it also comes with kind of a lot of xenophobia and kind of suspicion towards minority communities. And again, if you just do a survey of theories of multiculturalism in typical kind of Anglo-American political theory texts, the figure of the, let's say, illiberal minority, and what is it that they get up to, and are they oppressing the minorities within the minority, and so on. And so much of it just seems to be kind of veiled imaginations or kind of imaginary projections of the supposed Muslim minority that is lurking in, I don't know, Tower Hamlets or elsewhere in East London, or, the Bronx or whatever, who knows, like it's always kind of these constructions which are often weird and in most instances kind of veiled and, euphemistically kind of alluded to, but it's often very divorced from the reality and, how things actually play out. But I think so much of this, at least in those kinds of theories, is kind of a problem of framing and projection.
And I think this is a sort of a general trend that I guess you can see in popular discourse about multilegality, which is that the presumption, and I distinguish in the book between the stuff of law and these what I call practices of legal pluralism, ways of making sense and kind of enacting, bringing about, enunciating what the multiplicity of laws is. And in that second, if we make that distinction, it's that at the level of practices of legal pluralism, the most common practice is a practice which presumes incommensurability, right? That state law is, unless proven otherwise, inconsistent with, different from, retrograde with respect to state law. That's a very common, and definitely in terms of Islamic law, but other non-state legal regimes as well. I mean, I think just religious law generally, the feeling is always, or the impulse at the level of practicing legal pluralism is always towards that presumption. And one thing that overlooks, that I didn't get to really talk about as much in the book, but I would have liked to, is that like any legal system that's standed the test of time has or legal systems, internally multiple legal systems, legal traditions, I should say, they've always been coexistent with and in conversation with other normative systems. And the assumption in most parts of the world for most of human history was that law is not singular but multiple, right? So this idea of legal monism, the thing that we take for granted in secular modernity, is so recent and narrow in its footprint, both geographically and historically, that it's the fact that we can take that as the starting presumption is very much not helpful definitely from a historical perspective. But it also what is particularly short-sighted about is that if you look, for example, at the history of Buddhist law is always, or say Vinaya, just the more narrow form of monastic law, even in the accounts that are given in the Vinaya about what the Buddha was reputed to have said with respect to the formation of Vinaya law, even the Buddha is saying, look, this needs to be aligned with state law. Like, so the idea that these things exist apart from state law, or that the imagination of these systems is somehow apart from state law, is just patently wrong. And so, at least in the development, if we think about the development of law over time, I don't think there's many legal normative regimes where the trend over history is towards incommensurability. I think in most, to the extent that most legal regimes grow up in multi-normative settings, to the extent that multi-normativity, multipolarity of law was the default state of human life for most of human history in most parts of the world, we shouldn't assume then that legal regimes or any non-state legal regime would instinctively be incommensurable with state legal regimes. I don't think that kind of assumption holds up across time. I mean, I haven't done a comprehensive study of this, but that's just my instinct based on looking at the examples that I've spent time looking at.
Thinking about legal pluralism, I'm wondering whether it might have anything to tell us about international law as a category, and then perhaps also the discomfort that perhaps some of the stronger powers today have with international law being applied to them as opposed to applied to others. Particularly, I'm thinking now many war crimes charges in the world today.
So there's two, I think, comparators that have always been in the background of discussions of legal pluralism. One is various forms of non-state law, domestic non-state law. So whatever the norms of particular communities, religious laws, whatever it is. The other is international law. And the thing that those two things share is some kind of, I guess, skepticism about or uncertainty about the possibility of sanctions. So, the thing that has defined state law for a lot of, jurisprudence people, like from HLA Hart onwards, the positivist kind of view of law, or I would just say, I mean, the positivist view of law has just lingered in the background basically for still, I think today is the dominant way of thinking about law, and central to this is basically the ability of enforcement. So to the extent that religious communities don't have jails or polices, or to the extent that they rely on ostracism or social sanction, that's not considered real law, real hard law, or whatever. And it's of course the same with international law. That's exactly the same skepticism that you would extend to Buddhist monastic communities on those grounds. Although we can talk a little bit about what sanction looks like in a Buddhist monastic community, we would also extend to international law. And so I think we're seeing at the moment like a retrenchment of a real positivist kind of monist view of law, right? I mean, that this is, but even, and this is not news to you or to anyone who is in religious studies, but even the kind of monist world of state law that we would want to fall back to is not religion free either, right? So that these structures have a history that can be traced back, by some, but Harold Berman traces it back to reformations in the Catholic canon law and so on. Like, why do we have 12 members of a jury? Why do we have the reasonable doubt standard? Like, all these things have a religious history, and of course, as interpreted, they can be interpreted through a certain kind of religious lens and so on. So there's a way in which I guess that is how I see the portrait. That's how I see the continuity with international law, or the similarities, is the same skepticism that we bring to non-state law because of its ostensible non-positivist or lack of like real coercive powers. We also bring that to state law, international law.
Yeah, I think that's right, and I think that really kind of the underlying kind of unstated premise in a sense is the centrality of the state in much of this thinking, that it somehow is a association that is to be kind of privileged above all other associations. And then number two, I think another dimension to this is that within this thinking, there's a tendency to think of law as that which is connected to either sanction or some other coercive apparatus, as opposed to other categories which I think are often in many legal systems thought about as law, but in this way of thinking would be kind of relegated to something else, such as ethics. So, so much of what is considered law in, let's say, the Sharia is stuff which actually there's no sanction on it. It's just stuff that you kind of know personally in your own conduct is stuff that you either should be doing or shouldn't be doing, or it's preferred that you do or it's preferred that you refrain from. But, technically that's all law as far as the Sharia is concerned. But again, I guess within this kind of thinking, this would be the domain of something else.
But also, I guess 2 points on that. One would be to say, so much of state law operates through, I guess the distant threat of sanction, or the distant threat of, coercive force, but is not the kind of, predominant mechanism through which it's acceded to, right? So there's social stigmas from breaking laws. Most of us, the classic one is speeding, right? Like, so you're worried about the cop pulling you over, but there's lots of other reasons we obey speeding laws as well. And so does that mean that that's at that moment where we're not afraid that we're, not speeding for a different reason? Are we following a different set of norms? Are we following state law, but through a different mechanism? And then equally, I think on the other side, what people don't take seriously is the actual supernatural threats that are very present in religious law and Buddhist law. So one just leitmotif, or one thing that I kept coming back to in my study of the monastic legal system, and people who read the book will see a lot of this in the second part of the book, is all the steps that monastic judges take to avoid making a bad decision because they're absolutely terrified of the karmic consequences of improper judging, namely going to hell, basically. So there's a lot, if you act, immorally, these are not kind of hypothetical, fanciful, like kind of, these people are really freaked out about this, and so supernatural sanction, I would say, or karmic sanction, exerts as much a constraining force, if not more of a constraining force, than my local speeding laws. So even if we want to stick to law is the thing you don't do for fear of sanction, if we extend our notion of sanction beyond the immediate threat of coercive force by a local constabulary to include these other very real, again, I would say, I just want to make clear, being reborn in hell is a real thing that would happen to you. Then all of a sudden, again, the reason not to include other forms of law, religious law, seems to make a little sense as well.
You just reminded me of, there's a prophetic hadith to the effect that there are three, judges are three. Two of the judges end up in hell and one is in heaven.
But so there's an interesting detail that was that one of the monastic judges I was interviewing, or actually a few of them mentioned this, which is that I was asking about the formation of the hierarchy of courts. So the Ramanya Nikaya system has this elaborate hierarchy of courts, district court, high court, Supreme Court sort of thing. And I was asking about like when and why cases get appealed to the Supreme Court, and why was it important for the Supreme Court to rule on certain kinds of matters but not others. And one of the refrains that I kept hearing was, look, these are the most experienced, most senior people, and therefore it's the greatest likelihood that they won't make the wrong decision and end up in hell. Like that these people are taking the burden away, or of someone, because even if you, according to these monastic judges, even a decision given in good faith but wrongly could land someone in hell. And so therefore, it was very important for really consequential decisions, like whether or not someone should be expelled from the monkhood or so on. Those should be dealt with by the most experienced, most knowledgeable people.
Yeah, it's funny because, again, I'll just elaborate on the remainder of the hadith. It says, so again, three judges, two are in hell, one is in heaven. One rules not according to the truth or according to the right, according to injustice, basically. And he knows, so that one is in hell. one does not know, basically kind of makes a mistaken ruling, but therefore squanders people's rights, that one goes to hell too. And then there's only the one who actually rules, by what is right, and that's the one who ends up in heaven. So it's, again, like you said, it's this similar kind of threat of the big responsibility. It's not only whether you're doing something knowingly unjust, but also the responsibility of being ignorant or being kind of careless in your ruling.
Yeah. And I guess that, this is part of maybe a broader conversation about, there is one argument for making a very narrow definition of law, which is that if we want to kind of point to the peculiarity of state legal practice, there are certain things that are peculiar about it. It's modernity, it's kind of recent advent and so on. Okay, well then let's by all means just call that's the only thing that gets the label of law. I would like to call that state law. But the fact of the matter is that in the world we live in, there's two things. State law, it has a certain cachet and prestige, and the category of law it does, that I want to extend to other normative regimes, if for no other reason than to bring them into the conversation, in the comparative conversation with state law. So there's just an instrumental reason for doing that. But then there's another thing, which is that I've referred to this recently as the legal uncanny. There's a way in which a lot of these non-state legal systems, including the monastic legal system, they very much see themselves in reference to state law, or that there is a way in which even when in the self-presentation, in the kind of discursive context in which monastic jurists find themselves, state law is always the implied object of comparison. And so to kind of set aside state law as the only law, is also kind of inaccurate from that perspective. So whether or not we like it, the category of law is left the stable, right? Like we can't put it back into just the body of the nation state. It's already out there in other ways. And so I think as scholars, people that are working on these kinds of issues, I think while we do want to parochialize and think about the distinctiveness of the state legal regime, I think we've done less well I think it's more important for us to think about opening up the boundary a little bit more, opening up the membrane rather than shutting it off.
Two things that this got me thinking about. One is there something that we can say about this kind of positivist divorce between ethics and law, which kind of flies in the face of what we were just mentioning about this kind of the judge ruling a certain way or behaving a certain way with this kind of sanction hanging above their heads, which is really the domain of ethics then. So this is one kind of whole conversation we might have. Another...
But it's only the domain of ethics if we think about this as, if the frame of reference is the individual and the moral impulse of the individual. I don't necessarily think we have to think about it that way. If we think about the person or persons who are bound by or constrained by the potential threat of hell, it's a community, right? So I guess we could call it a communal ethics. I'm not sure I find because the ethics distinction in my mind, I'd love to hear what you have to say. And you know a lot more about this than me, but to my mind, when you call something ethics, not only are you pointing to the self-restraint quality of the thing, right? So rather than the exteriorization of sanction, it's really what distinguishes ethics is about self-restraint. Mm-hmm. But also there's an individual, it's sort of presuming that the object of inquiry is the individual and that person's conscience. And if we for a minute suspend those two things, if we think about the threat of hell as binding on a community and actually an exteriorized threat, like it's real, right? I mean, it's not as though, even if you didn't self-bind in that way, from this perspective, you would still go to hell. Would we still think about it as ethics? Why not think about it as something like law or law?
Yeah, I think the important dimension that I would bring in here is that, yeah, you're right. It's the entire community that in these instances is responsible. So it is kind of more like a communal ethics, because I think, there's some cynical interpretations of religion which kind of delegate responsibility to like one person or another, right? So there's this, there's a certain attitude, for example, let's say this is a kind of a Najdi, kind of in Central Arabia, phrase that some people might say. They'll say, حط بينك وبين النار مطوع, right? So place between yourself and hellfire, colloquially, it's kind of like a religious person, right? Or a cleric or whatever. Why? Because the idea is that I'm not responsible for the legal opinion. Go just ask some guy, and so long as he says it, then he's responsible. He can go to hell if he wants to, right? Obviously, that's a very cynical attitude towards seeking legal opinion. And really, what is belied by this is the fact that the person knows that they're responsible, but they're like, I want to do this. I'm just going to get some guy to tell me that it's okay to do. When in reality, there is a communal responsibility. So if you see, and I think this is where the question of accountability comes in, right? Because if you find that, let's say, all the judges in your community are corrupt, are giving bad legal opinions, and you know it as a community, something has to change, right? I think then the responsibility then falls on the community, right? To do something about that, to change that situation. Likewise, state officials, likewise, bureaucracy, whatever else. So I think this is where you have, again, in Islam or in the Sharia, the notion of different kinds of obligations. Some of them are fard ayn, the kind of individual obligation, whereas others are what are called fard kifaya. So this is a collective obligation, and it then falls on usually kind of the immediate circle. So let's say if we're talking about judges, it might fall upon their colleagues to say, wait, this guy is corrupt, they need to be removed, somebody needs to replace them, whatever. But then if it's a bigger problem, and then it falls on the wider circle, right? So then it falls on, let's say, the community as a whole to say, no, all our judges are corrupt. We need to kind of do something about this, or we need to train more judges elsewhere. Some problem is here. So there's something that needs to be rectified. But then you have this
you're pointing to the reforming power, the reforming impulse and set of values from which the reforming impulse comes as the ethics, as opposed to the law.
It's both. I mean, it's one and the same. That's the thing. I think this is what I meant was the fact that what we typically now, in a positive mindset, would say this is ethics, that's law, these, and never the twain shall meet. These things are much more interrelated because, like you said, the threat of hell is real, right? It's not and therefore, again, the fact that when you're behaving in a certain way, even though there might not be a worldly punishment or sanction for XYZ actions or behaviors, the fact that both that and those other things that do have a worldly sanction have the threat of hell behind them. If anything, actually, it's the other way around, where those, let's say, crimes which, let's say, murder or whatever else, which do have a worldly sanction, you have a chance to repent.
Yes.
And maybe then, even maybe the punishment or the is kind of expiation for the fact that you might not then need to face hell later on. Whereas these other much more, in a sense, minor things, they have the threat of hell behind them. Sure, obviously there is a chance to repent, but again, without that chance to kind of face the deed, maybe there's less of a chance for that to actually happen, or less incentive for that to happen.
One thing that comes to mind here in our discussion is that, at least I guess for the jurisprudence, the legal theory people, I think there's, I guess, maybe three dominant ways in which law has been framed and imagined. One is the positivist one that we just talked about. It's the positing of the command of the ruler kind of thing, and then that enforced. The other, of course, the other dominant one for a long time was the natural law theory of law, right? Which we've largely, until recently in the States, was largely discredited. But I want to come back to in the Buddhist case because I think it's interesting. And the third is this relational theory of law, that law is much more is negotiated and it sort of emerges through certain kinds of relationships and so on, which I suppose I would fall into in a way, I guess, with my framing of things. But coming back to the natural law, I would want to call some of what we've been talking about sort of natural law. And in the Buddhist at least in the Theravada framing of things, this is like really a law, right? Like there are some versions of, in the Burmese Buddhist tradition, like the Dharma, the teaching of the Buddha. The word Dharma is an interesting word, and it's, among other reasons, it's interesting because it means not just the teaching of the Buddha, but like the way things really are, like the laws of physics, right? I mean, you can teach physics, but physics exists whether or not you teach it. So Dharma is like that. Karma is part of this law of causality, is part of the Dharma of Dharma. And then there's these traditions of Burmese Buddhist law, or Burmese law. I mean, whether or not it's Buddhist, but it's also a state law. Dharma is literally written on the boundary wall of the universe in letters the size of cows, right? Like this, like the law is there. So you can, in your circumstance, in the circumstance of the immoral judge or whatever. Yes, the immoral judge, there is a certain lawful, they are claiming a certain status to speak for law, but actually the law, in your example that they're claiming to speak for, is not just, it's an eternal law that actually can be observed in spite of the dictates of that person. So that person would just not be following, if you like, I don't like the term natural law, but Dharma is a kind of a natural law, right? I mean, it's literally out there. So, that's another thing I don't think we've taken seriously enough, even in positivist thinking about law, which is that, people always, this is something that comes up in law schools all the time, of like, what if they passed a law against, that prevented redheaded kids from going to school or something like that? Would it be a law? And that what that question in effect raises is the importance of this idea of natural justice or justice thinking within what we think about as state law. So it's also there. We just don't like to acknowledge it. It's interesting that and here we just circle back to the secularity thing. I think there's a way in which a couple hundred years ago we would be much more willing to acknowledge the natural law or justice aspects of even state law in a way that would just because of the myth of modernity, because of what we take to be the preeminence of secular power, or internally to the discourse, you wouldn't call it secular power, but secularism, we don't want to acknowledge the natural law part of our state law, right?
Yeah, absolutely. Speaking of natural law, I know that, I haven't read it in depth, but I know that Anwar Iman at University of Toronto has done quite a lot of work on that with regards to the Sharia and with regard to Islamic law. Also, speaking of natural law, and again, I guess the prominence of that concept, particularly in Catholicism, 6 out of 9 Supreme Court justices are Catholic, and the 7th grew up Catholic. Are we going to have a resurgence of natural law thinking in the U.S.?
Are we already seeing that though? This is now we're really going far afield here in our conversations. I think we've started to see, Robert George and so on. We've started to see, I think, a resurgence in this kind of area of legal theory. And I think, again, it's hard to know. I think it's always been there, right? I just think we're now sort of acknowledging the influence of, you can put it a lot of different ways, right? Strong ideas of justice, strong ideas of religiously derived ideas of morality inflecting the way we interpret and make laws. It's always been an interesting fact of the Supreme Court in the U.S. Just the composition and the more than less religious kind of disposition or composition of the judges. Yeah.
So from what we've been discussing, what can all of this tell us, if anything, about secularism and the way we think about secularism typically? We discussed legal pluralism and the kind of complications with that. We also discussed the state. But what does it even mean to talk about secularism today? And what is the future of secularism? Or are we just thinking about it in the wrong way?
So this is, I think, more your terrain than mine, but there's a few things that come to mind that I hope are implications of this work and other work I've done in the area of Buddhism and law, or Buddhist law, I would say. One thing is to say that secularism is both important and unique and not important and unique. It's important and unique in that I do believe that a lot of the default assumptions and implied comparisons that we make in the domain of comparative law take the secular state as a uniquely important formation, and therefore, whether or not we like it, whether or not we agree with its pretensions, with what it says about itself, with its self-presentation, we do have to take seriously its internal logics. And so understanding the internal peculiarities, if you like, the particular kinds of contrast that are unique to secular legal formations is important, and especially important in the world today. But at the same time, we also have to acknowledge or bring into the conversation lots of different alternative ways of divvying up the world into spheres, right? So that I would say that there's a way in which secularism is both unique in the ways I've just mentioned, but it's also a species of a more general genus, which is a desire to kind of break up the world according to certain the qualifiers. I'm not sure I want to go on record saying, but something like immediate and non-immediate spheres, or proximate and ultimate, or something like that. And so if you look, say, for example, in the logics that are operating in the Buddhist legal tradition, or in Buddhist traditions generally, you do have analogous moves being made, right? Like there is an idea, an old Pali idea, not terribly widespread in Pali literature, but influential later on, about that the world is, you can think of the world as involving the wheel of Dharma and the wheel of power, right? The wheel of the teachings of the Buddha as mediated, by monastics and so on, and the laws of the universe that are embedded in there, and the wheel of power as wielded by the king, and the domain of politics, and the domain that is about punishment, particularly. That these are distinguishable. Now you have to have both, and they both need to be running in parallel for a well-functioning society, but they're distinguishable. Or if you look at some of the legal materials I was looking at for this book, I mean, it is a common refrain in Katikavata literature that the lawmaker, the writer, will distinguish between the so-called orders of the king and the orders of the Buddha, or the commands of the king and the commands of the Buddha. So these things are seen as distinct. Are they secular, non-secular? Not exactly. But there is a distinction, or in Tibetan Buddhism, there's a distinction between Chos and Shrid, right? The Chos is kind of like Dharma, the timeless law of the universe, and Shrid, like the temporary orders of the king. The temporality is a kind of an important distinction here. But if you look at classic Tibetan political theory, they talk about a dual system. What are the two parts of the dual? This timeless law and this temporal law of the king, and so on. So there are these different ways of breaking things down that I think we can bring into conversation with the sort of de facto hegemonic liberal legal secular that we tend to see everywhere. And that I think that once we kind of open up the conversation to those comparisons, not only can we see, the disproportionate influence of the first, but we can also see the importance and the conversations that are happening between that and the second. So I would really like to, what can we learn from the study of Buddhist law or Buddhism and law to think about the modern secular? We can look at these ways in which, with two things, the ways in which secular power has had a certain kinds of influences on Buddhism and led to certain outcomes. So certain ways of thinking about Buddhism that reproduce or are subject to the categorical distinctions that are operative in secular power. So we can think about, the political and legal circumstances which have made, for example, in colonial Sri Lanka, if you look at my book, made the distinction between the, quote, civil aspects of Buddhist law and the ecclesiastical aspects of Buddhist law necessary. So if colonial judges are going in, they're looking at this mass of, Buddhist normativity, and they're saying, no, these are the civil bits, which we can touch, or the secular bits, effectively. These are the ecclesiastical bits, and sometimes they call them purely spiritual bits, which we will not touch. So secular law sort of has to get reproduced down to even within the Buddhist legal regimes, because these logics are so dominant and taken to be kind of almost natural categories. So that's one thing we can take, is the way in which that it affects down. But the other thing we can do is we can, I guess, contextualize and look at the ways in which these other ways of engaging with domain making have influenced Buddhist life in ways that secular logics either defy secular logics or sometimes complementary with secular logic. Sometimes they overlap with them. But it's important that we recognize that the historicity and the ongoing prominence of these things as well. So that would be the other thing I would want people to take.
So for the final word, what, if anything, would you like any readers of your book to either take away from it or things that you would like them to engage with, perhaps for future research or otherwise?
I mean, for me, I guess there's the general and then the specific. I guess the more general, they're both general and specific in their own way. I mean, I'm really passionate about the idea, or about I want people to take Buddhist legal traditions seriously. I would really want people to read the book and think, wow, I came to writing the book. I didn't know much about these monastic legal traditions. I didn't understand the way they were, like, the history of coevolution with state law, the ways that I didn't understand their sort of robust and kind of complex and really amazing internal apparatus. I didn't know about, this is another way of thinking about legal process, another way of thinking about dispute resolution. There's kind of interesting elements of thinking about the function and role and nature of law. Like, I'd want them to kind of the main thing is to open that up. The second thing would be to look at, the history of interaction between state and non-state law in Sri Lanka, and particularly, Buddhist legal traditions. So how have these two legal traditions entangled and informed each other, and in the way it's gone both ways, right? That would be the second thing. And then the third thing would be to use it as an opportunity to think again about legal pluralism generally, and to make an effort to think in other contexts about what do we get when we distinguish between what I call legal artifacts, the stuff of law, the things in the world, and what I call practices of legal pluralism, the ways we bring order and meaning to those things. What would happen if I take the same theoretical rubric and apply it to another case in which we have things and we have these different ways of making sense of things? What would it mean to think about multi-legal settings in other parts of the world as a plurality of legal pluralisms, as this kind of field of multiple multi-legalities? How does that change the way we think about the cases that we're looking at? So I guess those three things.
Fantastic. Thank you very much, Ben, for joining us. This is fun.
Thank you.
And to our listeners, we do hope you enjoyed this episode, and we welcome your comments, feedback, and suggestions. Send us an email at proteanview@muftah.org. If you're hearing this on Spotify, Apple Podcasts, or YouTube, we'd really appreciate a 5-star review or a like. This helps improve the visibility of our show. With your support, we can keep Protean View running and gradually improve it. Visit us at muftah.org and navigate to the Protean View tab to see all our episodes, and follow us on our socials using the handle @ProteanView, including on Patreon, where you can become a paid patron and receive exclusive content. Until next time.